morning, everyone, and welcome to our Q&A video on U.S. Fiancee Visa. Last week, we posted an announcement in our social media and asked our Filipino and American friends to write down their questions in the comment section of the post. And now, we are ready to answer your questions with the help of our own immigration attorney from Fickey Martinez law firm. We have attorney Francesco Fickey Martinez.
Before we get into the questions, something that needs to be stated is that the U.S. Embassy in Manila is one of the busiest consulates in the world, actually one of the top 4 busiest. It is very close in processing time to Mexico, India, and China. Due to Manila, Philippines, the U.S. Embassy there being one of the busiest, there are slower processing times, and it can take slightly longer for a fiancé to arrive in the United States or to acquire a fiancé visa due to the embassy's backlog.
So let's start with question number 1. Currently, many people are getting laid off due to coronavirus. Unfortunately for me, I may be one of those people. I had submitted for a K-1 visa for my fiancé 2 months ago. Will losing my job affect the acceptance of my fiancé with the new rules and guidelines that were released at the end of February? According to the person who wrote this question, I had a solid 5-year background in one career path, working with a good income.
To answer that question, income is very important in the fiancé visa process. The fiancé visa is actually a 3-step process. Step 1 is the petition, where the U.S. citizen is showing the eligibility requirements for the fiancé visa. In step 2, at the consulate in Manila, or embassy in Manila, that is where the finances are assessed by a consulate officer. Questionnaires, an affidavit of support, tax returns, pay stubs, all of those items are provided to an immigration officer, a consulate officer for review, and a certain amount must be made by the U.S. citizen petitioner in order for the Filipino fiancé to receive a fiancé visa. So in short, the income is important, but if a filing was submitted 2 months ago, there is still time to either acquire the same job. It's unknown if the layoff is permanent or temporary. And if that isn't possible, then to acquire another job, hopefully in the same field, so the 5 years of experience can be rolled over. With so many people being laid off in the United States, or even before this epidemic began, the consulate officers would look at the pay stubs of an individual to show current employment. Ideally, 6 months of pay stubs are solid, but if there's something less than that time period, a consulate officer is able to accept the pay stubs and possibly also a letter from the employer to show that the employment is not temporary, it's permanent, and it will likely be permanent or current when the Filipino fiancé enters the United States as a fiancé, K-1 Fiance visa holder.
Okay, and he has a follow-up question for that. What happens if I get accepted and my fiancé needs to travel to Manila, Philippines to go and attend the U.S. Embassy interview? Manila is currently on lockdown, and so is Cebu. Are they postponing all appointments until later?
That's a good question. With the coronavirus affecting the entire world, the U.S. consulate started closing or not scheduling appointments starting in March of 2020. With the travel ban, the 60-day travel ban that went into effect last week, fiancés are not able to get scheduled, and the consulates will not be spending time on those cases. However, again, going back to the point that the filing was submitted 2 months ago, the filing is still likely pending at the U.S. agency USCIS before it is sent to the National Visa Center and then over to the consulate in Manila. So there's still plenty of time. You may not see a delay.
Okay, our next question is a little bit in general. Can my fiancé drive and work immediately as soon as she arrives in the United States?
So the ability to drive and work requires documentation. The fiancé visa is only created for one purpose, and that is to marry the United States citizen. It can be used to get a social if the marriage occurs early on the 90-day authorized stay, and a driver's license can be acquired after that, but generally a driver's license is only valid up to the 90th day after entering on the fiancé visa, and employment is also difficult as many employers don't know what to do with fiancé visa holders, and the fiancé is in a paperwork process, paperwork turmoil, where the government's trying to catch up and issue documents such as the lawful permanent resident or green card, or an employment authorization document, which is a red card. But with a social and being here, work is possible, but without a documentation, it's very hard. You wouldn't be able to drive after the 90th day. So there's some things that can happen, can't happen. Timing. The best thing to do after marrying is starting the adjustment of status to acquire the green card, which would permit work and driving and things like that.
How quickly can my fiance come to the USA if assuming I'm going to start filing today?
So the fiancé visa process is a 3-step process. Step 1 roughly takes anywhere from 3 to 5 months. The processing time differs throughout the year. That process goes from USCIS, step 1, USCIS, to the second step, where USCIS sends the file to the National Visa Center, where a NVC number is created, and then that file is sent over to the embassy or consulate, in this case, Manila, Philippines. The Philippines usually receives a fiancé filing about 3 to 4 months, possibly longer, after the first step is approved. So 3 to 5 months for the first step. The second step can be 3 to 4 months, or possibly a few more weeks or a couple more months thereafter. So the fiancé could be in the United States roughly within 6-7 months, but it could be closer to 8 or 9 months, just because Manila, Philippines is busy.
I am from the Philippines, and my U.S. citizen fiancé submitted my fiancé visa petition and included a Philippine birth certificate coming from the National Statistics Office, or NSO. What would be the possible consequences?
With Filipino birth certificates, an NSO birth certificate is not accepted. It hasn't been accepted in the United States or with the U.S. immigration system for a few years. Only the PSA version of a birth certificate is required. If an NSO is provided to USCIS in the initial process, technically that birth certificate is supposed to be rejected. If it isn't, when you go to the embassy in Manila, the PSA birth certificate is the only one that is accepted, and there are many notices in the instructions for the fiancé visa process that state only PSA is acceptable for the birth certificate, for the Cinemar, and for documents like that.
Do I need a certificate of no marriage or Cinemar even if I am divorced or widowed?
Yes. Cinemar means that you are eligible to marry and you're not married to anybody else. If a U.S. citizen was trying to marry in the Philippines, they would need something equivalent. It's an affidavit of ability to marry or eligibility to marry, that you're free to marry. That is something that's vital to the fiancé visa process because you need to still be fiancés and not spouses. So yes, a Cinemar is needed, even if you've never been married, if you're divorced, or if you're widowed.
Thank you so much, Attorney Francesco Fickey Martinez. That's it for now, friends. If you have a specific questions regarding your case, please contact our immigration office to schedule your appointment. Thank you.